Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in.
Welcome to the Deep Dive. We're here to tackle complex topics and pull out those really crucial insights for you.
Glad to be here.
Today, we are diving into something called legal professional privilege. You might know it as LPP.
Mm-hmm. Absolutely fundamental.
Exactly. It's critical for anyone in the legal field, really. So our mission today, to give you a clear, practical overview, think of it as your guide to understanding LPP, protecting it, and spotting the risks.
And we're drawing on some excellent practical guidance designed for lawyers, particularly thinking about the Australian context here, but the principles are broadly relevant.
Great. Okay, so let's just jump right in. What exactly is legal professional privilege? Why all the fuss?
Well, at its heart, LTP is a legal principle, a really basic one that acts like a shield.
A shield?
Yeah, it protects the confidentiality of talks, communications between a client and their lawyer.
Okay, and why is that shield so important?
It's fundamental to the rule of law, really. It allows clients to be open and honest with their lawyers, completely honest, without fearing that what they say will be used against them later.
Right, so they can get proper advice.
Precisely. It lets lawyers give accurate, effective advice. And here's a key thing. It's not just a rule about what evidence you can show in court. It's what's called a rule of substantive law.
Substantive law. So it exists outside of just court cases.
Exactly. The High Court in Australia really cemented this idea. It's a fundamental right, not just an obstacle during litigation.
That's a really important distinction. So it's this fundamental right. It must have different types, right? It sounds like it covers a few different situations.
It does, yeah. There are two main categories based on the purpose of the communication.
Okay.
First, you've got advice privilege. This covers confidential chats, emails, whatever, where the main point, the dominant purpose, is getting or giving legal advice.
The general legal advice.
Pretty much, yeah. Doesn't have to be about a court case specifically. Then there's litigation privilege.
Okay, sounds more specific.
It is. This protects confidential communications made when the dominant purpose is for use in litigation, a court case that's already happening, or one you reasonably expect might happen.
Got it. Advice privilege for general counsel, litigation privilege when things get more formal.
That's a good way to put it. And, it's evolved. It started more focused on litigation, but key cases expanded it. And now it's also written into legislation, like the Uniform Evidence Acts here in Australia.
So it's well established in both common law and statute. But how does this legal privilege compare to, say, the lawyer's general duty of confidentiality? They sound pretty similar.
They do sound similar, and they're related, but they're definitely distinct. Think of them as different layers.
Okay.
LPP is a legal right the client holds. They can use it to legally prevent disclosure, usually in court or discovery. The ethical duty of confidentiality, on the other hand, is broader. It's a professional rule for the lawyer.
So it covers more.
Much more. It covers basically all information the client shares, whether it's technically privileged or not. And that duty lasts forever, even after the case is done. LPP is narrower, focused on specific communications for those legal purposes.
Right. It clarifies things. Okay, let's get practical. For the lawyers listening, if you're advising a client, what are the absolute essential ingredients for a communication to get that LPP shield?
Okay, yeah, this is crucial. There are basically 4 key things you need. First, pretty obvious, you need a lawyer-client relationship. The communication has to happen in that context, client seeking advice, lawyer giving it professionally.
Makes sense. What's next?
Second, confidentiality. This is vital. The communication has to be intended to be confidential, and you have to keep it that way.
So don't go sharing it around.
Exactly. If you share it with unnecessary third parties, you could lose the privilege right there. There was a case, Tech Headland, where just copying someone who didn't strictly need to be involved into emails waived the privilege.
Wow. Okay, so keep the circle tight was number 3.
This is often the big one. Dominant purpose. The communication must have been made for the dominant purpose of legal advice or litigation. Not just a purpose, but the main overriding reason.
Dominant. That sounds like it could be tricky to prove sometimes.
It absolutely can be. It's judged at the time the communication was created, and if a document, say an internal report, has multiple purposes, maybe business strategy, risk assessment, and getting legal input privilege, might not attach if the legal purpose wasn't the primary one.
So you need to be really clear about why you're creating that document or having that conversation.
Precisely. Documenting that purpose at the time can be incredibly helpful later on.
Okay, and the last element.
The communication must not be for an unlawful purpose. LPP doesn't protect communications made to help commit or cover up a crime, fraud, or similar civil offense. If that's the purpose, the privilege is lost.
Right. The shield doesn't protect illegal activity. So those four things,
Yeah.
lawyer-client relationship, confidentiality, dominant purpose, and no unlawful purpose. Does this apply just to letters or?
Oh, it applies broadly. Any form, really. Verbal talks, face-to-face phone calls, written stuff letters, memos, notes, and of course, electronic things, emails, texts.
Even email chains.
Yes, potentially. If the dominant purpose of the whole chain, or maybe forwarding the chain, was about getting or giving legal advice, the whole thing could be privileged. But again, it hinges on that dominant purpose.
Okay, so we know how to get the shield, but you mentioned it can be lost. Waiver. Right. This sounds like where things can go wrong quickly.
Absolutely. Waiver is a huge risk area. LPP can be lost or waived, sometimes on purpose, sometimes completely by accident.
How does intentional waiver happen?
Well, it can be explicit. The client just says, yes, I waive privilege. Or it can be implied by their actions. If their conduct is inconsistent with keeping it confidential, like sharing the advice publicly or with an opponent, that can be a waiver.
And the accidental kind. Inadvertent waiver.
Yeah, that's usually carelessness, like mistakenly sending a privileged document to the wrong person in an email.
Oh, dear. Does that automatically mean privilege is gone?
Not necessarily, and this is important. Courts have recognized, especially after a key case called expense reduction analysts, that a genuine mistake, something not knowing and voluntary, doesn't automatically kill the privilege.
That's a relief, I imagine.
It is, but it doesn't mean you can be careless. If it happens, lawyers have an ethical duty, Rule 31, in the Australian Solicitors' Conduct Rules, to act fast, tell the recipient it was privileged, and ask for it back or for it to be deleted.
Right. You still have to try and claw it back immediately. What about sharing just part of a privileged document? Can that cause problems?
Yeah, big problems. That's waiver by partial disclosure. If you reveal part of a privileged communication, maybe the conclusion of legal advice, but not the reasoning, you might be forced to disclose the whole thing.
Why is that?
To prevent unfairness or misunderstanding, you can't just cherry-pick bits of advice to suit your case and hide the rest. It risks misleading the other side or the court.
So it's often all or nothing. And if privilege is waived, what are the actual consequences?
They can be really serious. The information loses its confidentiality, so it can be used as evidence against your client. That can create a huge strategic disadvantage, potentially damaging their whole case.
Okay, very clear risks there. You mentioned common interest privilege earlier. Is that a way around waiver?
It's not exactly a way around waiver. It's more a principle that prevents waiver in certain situations. It's not a separate type of privilege itself.
How does it work?
Basically, if parties share a sufficient common interest in a legal matter, think co-defendants, or an insurer, they can often share privileged information between themselves without that act of sharing being treated as a waiver against the rest of the world. It allows necessary collaboration, usually in litigation.
Got it. So it preserves the privilege within that shared interest group. Are there other times LPP just doesn't apply, even outside of waivers?
Yes. We mentioned the unlawful purpose exception. Sometimes specific laws might override LPP, although courts protect it strongly unless the law is crystal clear. And in rare cases, a very strong public interest might override it.
And basic situations where it just wasn't there to begin with.
Right. If the advice wasn't actually legal advice, maybe it was purely commercial. Or if there was no intention of confidentiality or unnecessary third parties were involved from the start. Or simply if there wasn't really a proper lawyer-client relationship for that specific communication.
This has been incredibly helpful. Thinking about the lawyers listening, what are the absolute must-do practical tips for protecting LPP every day?
Look, the main thing is being proactive and vigilant. It sounds simple, but it's everything.
So what does that look like day to day?
Well, managing that dominant purpose issue is key. Document the purpose of communications where privilege might be relevant. Especially for in-house lawyers, try hard to separate purely commercial discussions from requests for legal advice. Maybe use separate emails or documents.
But what else?
Tackling inadvertent disclosure. Have robust procedures for handling documents and emails. Double-check recipients. Train your staff. And if a mistake happens, have a clear plan based on those ethical rules.
And third parties.
Be strict. Only involve people who are essential for the legal advice. Brief them on confidentiality. And manage electronic risks. Use secure methods for sensitive communications. Encrypted email, secure portals, things like that.
So system checks, training, and secure tech.
Yes, and maybe most importantly, educate your clients. Make sure they understand what LPP is, why it matters, and how their actions like forwarding an email could risk waiving it.
That builds trust too, presumably.
Absolutely. It's part of your professional duty, and it helps everyone stay protected. It's like doing a regular LPP health check on your practice.
A health check. I like that.
Oh.
So bringing this all together, what's a final word for our listeners?
Just to really emphasize that LPP isn't just some technical legal rule. It's fundamental to the trust between a lawyer and client. Understanding how it works, the elements, the risks like waiver, the exceptions, that's just essential for effective ethical practice. Vigilance is key.
Couldn't agree more. So take these insights into your work. Think about your own communication habits. And maybe ask yourself this week, how can you actively check that your privileged communications are meeting these standards? Are you documenting purpose? Are you careful about who's copied in?
A great challenge.
Thank you so much for walking us through this complex but vital area. It's been incredibly insightful.
My pleasure.
And to you, our listener, thank you for joining us on the deep dive. Stay curious, stay informed, and we'll catch you next time.
That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD Plus page linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.